Great news has surfaced. The Labor Party has submitted over 10,000 copies of Forms EC 8A, all of which are copies provided by their own party agents. This move aims to put an end to the persistent question of why the Labor Party didn't present their own political party agents to substantiate their victory. It's worth noting that they submitted 3 types of documents: those given by INEC, copies from IREV, and the physical hard copies along with their party agent copies. Before delving into the analysis of this development, let's get updated on the happenings at the Presidential Election Petition Tribunal. The respondents were expected to submit their final addresses yesterday, and they did so, but unfortunately after the close of work. Consequently, no party can currently access the certified true copies from the court, hindering any analysis of the responses, arguments, and issues raised by the petitioners. However, it is anticipated that this matter will be resolved when the court resumes work on Monday. On Tuesday, all parties will assemble in court for the adoption of addresses, after which the court will either announce the judgment day or communicate it later. The whole process is expected to take no more than 2 weeks, considering the myriad of issues and prayers raised by the petitioners, including the PDP, Labor Party, and the APM. During the court proceedings, the judge's role is to interpret the law, though lawyers also play a crucial role in shaping their opinions and providing additional research. The final addresses submitted by the petitioners' counsels reflect extensive research and may cause some confusion. To clarify, the number of addresses the respondents have to make is quite simple. The petitioners, Labor Party, PDP, and APM, brought INEC, Tinubu, APC, and Shettima to court. After the hearing stage, the respondents addressed the court, responding to all the issues raised by the petitioners one by one. The respondents' arguments against the petitioners' claims are included in their first final address. The petitioners then have the right to counter the respondents' arguments, which leads to the respondents' second and final response, as they did yesterday. Now let's examine the significance of the more than 10,000 copies of Forms EC 8A submitted by the Labor Party, along with the 18,000 copies from IREV, which unfortunately appear blurred despite being stamped, certified, and given by INEC. It was expected that INEC would replace these blurred copies with the hard copies used in collating the results, but that didn't happen, and some of the results were even blank. Nevertheless, the Labor Party managed to turn this situation to their advantage. INEC's withholding of evidence seems to indicate their reluctance to present evidence that could potentially prove their wrongdoing in court. In their final reply, INEC argues that the Labor Party failed to prove their victory, and even suggests that the plea has been abandoned by the party. However, this tactic backfired, as the Labor Party successfully argued that since the uploaded results on IREV are identical to the hard copies, whatever INEC certified and presented in court should be considered as authentic. Even INEC's own witness acknowledged this fact during cross-examination. Therefore, the Labor Party managed to turn the tables in their favor, asserting that if blank and blurred copies were submitted, the results cannot be validated, as collating any result without visible figures is impossible. Now let's delve into how the massive evidence presented by the Labor Party was discovered in court. During the objections raised by INEC about the admissibility of some documents submitted by the Labor Party, they questioned whether the party had adequate evidence that those documents were made by the individuals who presented them in court. Essentially, INEC was attempting to find technicalities and argued that the Labor Party should have called the party agents, polling officers, and collation officers responsible for those documents to speak to their authenticity. However, this tactic failed to defend or counter the results submitted by the Labor Party. Moreover, INEC couldn't replace the blurred and blank copies that were presented as evidence. As a result, the court will have to make its decision based on the available evidence. The Labor Party's submission of its own copies of the results aimed to prove that INEC did not use the hard copies to collate the results, which would indicate noncompliance with the law, requiring result uploads to IREV for comparison at different collation levels. The evidence before the court shows that the results were not collated with the hard copies, as they did not match. The court will have to weigh this evidence to determine its implications. Considering the substantial noncompliance by INEC and the unaccounted for votes, possibly up to 20 million, it's evident that the noncompliance affected the election outcome. The court may need to decide whether to cancel the election due to these issues. While there may be concerns about the cost implication of conducting a fresh election, the court will have to work with all the evidence presented to reach a fair decision. Curiously, none of the respondents countered any evidence tendered by the petitioners. This lack of counter-arguments is surprising and may weaken the respondents' case. If the court decides not to cancel the election due to the overwhelming evidence and the cost implications, they will have to consider all the available evidence, including the figures provided by the Labor Party and the hidden votes in the blurred copies. The disqualification of Tinubu seems inevitable at this point due to the substantial and unchallenged evidence presented against him. The evidence, especially concerning the passport and certificate issues, is overwhelming, and the court must consider it in reaching a verdict. Ultimately, the Judgment Day will likely bring celebrations all over Nigeria, as the court's decision will have significant implications for the election outcome.